Swayam Prabha. Digital India. Educated India.
Namaskar friends, welcome to SwayamPrabha. My name is Dr. Parikshit Sirohi. I am Senior Assistant Professor in Faculty of Law, University of Delhi. As part of the course on cyber crime, this is the 7th lecture, and here we are going to talk about personal data privacy in the online context. Friends, in lecture number 5 and 6, we have had some kind of an understanding of what privacy on the internet is, what privacy in general, what it entails. The internet and the cyber world have added completely new dimensions to privacy. So, these are some of the things that we are going to be talking about, friends. First of all, the OECD principles. The principles which have been made by the Organization of Economically Developed OECD countries. There are 8 privacy principles which have been made by them. Then we are going to be speaking about the data privacy, the privacy of the customer, the privacy of the consumer, the privacy of the individual. Whenever we are accessing various websites, we are asked for information. Cookies are stored. So, the information policy that is there of various websites. What is informational privacy in the age of technology? We are going to talk about that, friends. We are going to talk about the experience of United States, how they have regulated the privacy for adults and children. I have briefly alluded in my previous lecture on the law which they have passed. Seal programs, privacy seal programs which authenticate, serve as some kind of standard for various websites. We are going to talk about that. We are going to talk about how data protection happens in the United Kingdom. And on the basis of what the UK has done, many EU countries have followed suit, friends. And we are going to talk about the data protection provisions in English law. What are the provisions in the Information Technology Act 2000, the international standards for protection of privacy, and friends, what is going to happen in this space in the future? What are some of the likely things that are going to take place in the future? We are going to talk about that, friends. So, first of all, friends, a very famous personality, Roger Clark. I am starting by what he has said. Privacy is the interest. It is an interest that individuals have in sustaining their personal space. So, in the previous lecture, we have talked about that the personal space and the public space of an individual are different, and we have to respect that line. Yes, sometimes that line may get blurred if that individual is indulging in seriously illegal activities like terrorism, drug trade, flesh trade, narcotics, gun running rackets, etc. How to make a bomb he is teaching on the internet, all those things, yes. But otherwise, privacy is actually the interest that individuals have in sustaining the personal space as distinct from public space, and this personal space must be free from interference by other people and organizations. So, what are the key definitions, key features of this definition given by Mr. Roger Clark? First of all, it is an interest. Privacy is the interest which individuals have in sustaining the personal space free from interference by other people and organizations. So, the key words are interest, the individuals, the sustaining personal space, interference by other people. So, friends, one dimension of privacy is personal data. We are generating so much of data, our preferences, what kind of what time we visit the website, how much time we spend on the website, what kind of shopping we do on the website, our behavior on the internet. So much of personal data is being shared, and so it is known as data privacy or informational privacy. So, this is one very important aspect of privacy today. The main point is that we have to understand that individuals can legitimately, legally, lawfully claim that data about them should not be made available to others. It is my data. It should not be shared with others without my consent. I should have control. I should have autonomy over what I am sharing. So I should have this autonomy, and this word is also there in the famous Puttaswamy judgment, which has been delivered by a constitutional bench of the Supreme Court of India in 2017, friends, 9-judge bench. That is popularly called the Aadhaar case. Friends, even when the data is possessed by another body, the individual must exercise some kind of control which is substantial over the data and what kind of use such data is going to be put to. Friends, all the persons who are desiring to control or influence the handling of data, every person, they have a desire to control or to decide for what purpose the data that is about them, it is being used for what purpose. So they want to control, they want to influence the handling of data about them. So it is natural that individuals feel the need for such a mechanism where their interest can be protected. Friends, all law involves balance. You have to balance the competing interests of different sections of society. In constitutional law, you balance the fundamental rights vis-a-vis the directive principles of state policy. In intellectual property law, you balance the interest of society with the interest of the convener, the inventor, the person who has developed the product, the owner of the IP. On the road, you balance the interest of pedestrians with that of the cyclist, with that of the truck driver, with that of the car driver. Everybody's interest has to be balanced in law. Somebody may want to listen to music, somebody may want to sleep at night, somebody may want to study, somebody may be sick and may need rest. So that is why you have these guidelines that from 10 p.m. to 6 a.m. the loud music, the religious songs, the marriage songs cannot be played. So every law involves balance of competing interests. In this case, we have to balance the privacy of the individual and other competing interests. One such competing interest could be, friends, national security. So on grounds of national security, there may be legitimate reasons to breach the privacy of an individual. I am just giving one example wherein the competing interest could be there. There could be some other interest wherein the organization says that I have a legitimate right to use that information for marketing purposes. There could be various instances, friends. There are 8 basic principles which I mentioned a few minutes ago, which have national application. There is the OECD countries have come together and they have decided that 8 principles they will make, which will be adhered to by all member nations in their national law. Now, the way any treaty works is that when the signatories come together, they have to make the necessary changes in their national law. Whatever is agreed in the treaty, they have to make changes. And who is the one who is going to be authorized to make these changes? The parliament of that home country. So that is why when the parliament approves it, it is called ratification of the treaty or the convention. This happens when parliament of that country approves it, because parliament is sovereign to make the law. So that is why it is national application. There are 8 such principles, friends. The limitation on collection of data, the limitation on quality of data, what kind of data, then purpose has to be specified, the use has to be limited, the safety has to be there in place when data is collected, the openness has to be there, the participation of the individual has to be there, accountability has to be there. We will talk about each of these principles one by one, friends. So first of all, the limits to collection of personal data is has to be prescribed. It is prescribed by this first limitation. The first limitation, it has to be obtained, the data has to be obtained by lawful means. Not only lawful, it has to be fair also. And as far as possible, consent or knowledge of the person whose data is being collected has to be there. The person whose data is being collected is called data subject. person whose data collected, person to whom the collected data pertains to is called the data subject, and such person's consent or knowledge, ideally consent, but if not consent, at least he must know that data is being collected, friends. The second OECD principle is the quality of data. The data must be relevant. For example, why should you know what caste I belong to? Why should you know what religion I belong to? If I have come to buy a newspaper, if I have come to buy a cold drink, if I have come to buy a banking service, why in the form should you be knowing what kind of caste or what kind of religion I come from? So, it must be relevant for the purpose for which the data is being collected. So, maybe yes, you may want to know how much time I spend on that website or what kind of products I purchase. It may be relevant to collect such data, but my caste, my religion is not relevant. Similarly, the data which is collected must be accurate, it must be complete, it must be accurate, it must be complete, and it must be kept updated at all times. So, data which is not accurate, which is not complete, which is not accurate should not be maintained, friends. The third OECD principles, friends, is the purpose must be specified. Why you are collecting, the purpose means why. Why you are collecting the data must be informed at the time of collection of the data or before the collection of data, but you cannot inform the purpose after the collection of the data. Once the data has already been collected, you cannot inform either at the time of collection or before, ideally at the time of collection or before, and the use of that data must only be for that particular purpose. You cannot say that the data is being used for lucky draw, whereas actually it is being used for telemarketing, only for that particular purpose for which it is intended. Friends, coming from the previous principle, we go to the next principle, which is limitation of use limitation. The data, first of all, should not be disclosed or made available to any other third party. It should not be made available for any other purposes. It should be used only for that purpose for which it has been collected. Only one exception is there, that law allows. The law allows the data to be used for some other purpose legally, then only, otherwise no other exception, friends. Friends, the European countries are far more proactive about protection of data privacy as compared to anywhere else in the world. Even in US, such high standards are not there when it comes to protection of data privacy. US consumers routinely give out their social security number, their mother's maiden name. Maiden name is the name of the mother before the marriage. Mother's maiden name, social security number, driving license number. Such information is routinely given out by US consumers when they are applying for a credit card or whenever they are dialing the credit card company for verification purposes. Such information is routinely given, but in Europe you cannot do this. They will not allow it. They are far more strict about this. US, yes, this happens. So, but the awareness is happening all over the world about the use limitation and the data privacy, friends. So, the fifth parameter or the fifth principle which OECD goes by is data is to be protected by reasonable security safeguards. What are the safeguards that are there? What standards are there? And there should be the customers whose data is there, the data subjects data. It must be protected against these kind of risks: loss of data, unauthorized access to such data, destruction of data, modification of the data, manipulation of the data, disclosure of data or use of data by somebody who is not authorized, friends. So, this is again something very important. Friends, the sixth standard is openness. The seventh is individual participation, and the last, eighth, is the accountability. So, friends, openness is a general policy which has to be followed with respect to development practices and policies which are relating to pertaining to personal data. it should be readily available to establish the existence and nature of personal data. You have to establish a general working of collection of data should be in a manner that is open and transparent. So, we can also call this transparency principle. Friends, Justice Brandeis has said about transparency, electric light is the best policeman and transparency is a very potent weapon. So, Justice Brandeis' words are, he is a famous Supreme Court judge, electric light is the best policeman and sunlight is the best disinfectant. That is what he says about transparency and openness, friends. So, friends, again the individual's participation, that is the seventh parameter, and this is a very important aspect. The individual, every individual whose data is being collected, every data subject should have these rights, 4 rights. Every data subject should have 4 rights. What are these rights? He should obtain from the data controller. The data controller is the person who is controlling the collection of data, and it should be ensured that the data controller is not in a position of undue strength vis-a-vis the consumer. Friends, he should obtain from the data controller or from somewhere else confirmation whether or not the data controller has any data pertaining to him. So, for example, I as a consumer should have a right to contact Google and say, look Mr. Google, do you have any data pertaining to me, and if so, please share it with me. So, I have a right to get this kind of confirmation. Similarly, the data subject has a right to have him informed about the data collecting pertaining to him. So, similarly, I have a right that Google should within a reasonable period of time tell me what is the data that they have with regards to me. There should be a reasonable cost that is charged for sending me such data. This cost should not be excessive, and it should be in a format which I can easily read and understand. It should be in a format which is intelligible to me. It should not be in very technical language which I don't really understand. Friends, again the data subject has the right to be given the reasons if such a request that is made by him is denied. So, if Google is not able to give to me the information whether they have data about me or not, or if Google cannot give to me such information within reasonable time, or whether they cannot give to me such information at reasonable cost, or whether they cannot give to me such information in a format which I can understand, which is non-technical in nature, then they must give me reasons why they can do so, and I should be able to challenge, I should be able to refute, challenge such denial by Google, who has collected my data, who is a data controller. So, in my example, Google is a data controller. So, friends, lastly, I should be in a position to challenge the data pertaining to me. Supposing Google has some information which is wrong, I should have a right to refute it, and if the challenge is successful, if I am able to show that what I am saying is correct, then I should have the right to have such data about me, about the data subject, either erased or rectified or completed or corrected or amended as the case may be. So, I have these rights as per the OECD principles, friends. That every data subject enjoys these rights. Last principle, and also reasonably prominent, important in the scheme of things, is the principle of accountability. Every data controller should be accountable for complying with the measures which are there to give effect to these principles which are mentioned. So, friends, in the age of new technology, the privacy has acquired a new dimension altogether. Hitherto, new dimension of the privacy of the information is there. Friends, every human being treasures, values privacy immensely. So, when I say treasure, I mean that every human being values it immensely. It is of great importance. Human beings tend to link privacy to concepts of personal freedom. Everybody wants their freedom. Even parrots who are caged, they want their freedom. Even animals in zoos, they want their freedom. So human beings are meant to be highly evolved. Even you have a pet dog, you put him in a room when guests come, he will not or she will not like it. You tie up your pet dog, he will not like it. Nowadays, even when we see buffaloes and cows who are tied, they are also always training at the leash. So this self-determination is what human beings want. The privacy gives them a sense of self-determination. Informational privacy is now all about informational self-determination and well-being of the individual. So friends, with the convergence of two major technologies, computer and telecom, we have now got something called internet. And with the convergence of this technologies or information communication technology which we have got, it is created a situation wherein it is very cheap, very easy, very inexpensive to have access to large pool of personal information. So previously, if you had access to somebody's personal information, you would have to, it would be in printed form, you would have had to access it using a photocopier, make copies, make 10 copies. Carrying that photocopy from place A to place B was reasonably difficult. Now, you have access to the internet, you are collecting information, it is almost free, and such information can be transmitted using the internet, and it could be sent to any geographical area, it can be shared with a third party, it can be sold. Various things are happening. In fact, you may have never done business with one particular organization, but you will be surprised how that organization knows everything about you, because that organization has already bought your personal data from another organization with which you must have done business before. So the amount of information people have about you is actually scary. You call up your favorite pizza joint, and the moment you give them your mobile phone number, they know everything about you. Where you live, what kind of pizza did you order last time. So they will say, sir, do you want the extra sausage toppings? I see that on 29th of November 2023, you had ordered this. Sir, it is your anniversary, so do you want me to send some flowers also? So the kind of information that people have about you is scary. We all in our phones, friends, have data hungry apps like Truecaller and Google Maps. The amount of data that these apps are transmitting to the rest of the world, yes, they are extremely convenient, made our life very easy, but the amount of information they are transmitting is absolutely scary. For example, friends, Truecaller, the principle on which it works is that if you have saved a particular number as let's say there is one particular number 9810130123, right, you have saved it in your mobile phone as Mr. A. Now, every time you dial this particular mobile number, you have saved it as Mr. A. So, and you are a subscriber on Truecaller's database. So, every time this person calls up any other person, and that other person does not have this person's mobile number saved, every time it is going to come on the other person's screen as Mr. A. So, your entire phone book is compromised. I am just giving one small little example. The other examples are, so many other things are there. So, for example, these modern day security apps like MyGate or Society Connect or No Brokerhood, how do they work, friends? They work on the same principle. They don't charge for subscription, but they have to they have to make so much of expenditure, deploy staff, training, database entry. Every building guard will have to be given a tablet, and but who's paying for all this? Friends, your data is being collected, and probably it is being used to send you various kinds of information, and that is how it is paying. That is the revenue model of these various apps which are there. So, the interoperability of modern systems makes it possible for even the smallest of businesses to collect data, to analyze data, and to distill data and find out identifiable information about individuals almost anywhere in the world. They have access to information which you would normally not give out to individuals. So all these pesky telephone calls which you keep getting from telemarketers, how do you get them? It is because the data has been sold, and this data is so refined. Everybody gets telephone calls of a particular type depending on what kind of income you have, what kind of spending you may have done in the past. So for example, if you have recently bought a used car or bought a new car or sold an old car, you will start getting lots of calls from the similar businesses offering the sale of the car or new car or car loan and all of that. The privacy issues which arise in this scenario are different, not only in scale but also in nature from the issues that have arisen in the past. The scale of these differences, the nature of these differences is very large, and it is very different from problems, similar problems which have been faced in the past. So businesses will do well to protect personal information. Individuals will conduct the business only if they trust the electronic environment. So that is why it is important that businesses should also understand the importance of data privacy. The larger businesses by and large understand it. The challenge is in the relatively smaller businesses to make them understand, and the next challenge is in the smaller or MSME sector to make them understand the importance of data privacy, because if the customer does not have trust, then he will be hesitant to do business online. MSME sector, friends, has a lot of potential, it is poised for takeoff on the internet e-commerce stage. So this is a good opportunity to train the MSMEs on data privacy. The other major area of concern is the information which is gleaned or gathered from children, minors. The children are particularly vulnerable, friends, because they lack the coherence, they lack the ability, they do not recognize the risk, they do not understand the inherent problems posed. Children are, you ask them one question, they are likely to give you not only that answer but also 3 more answers. They don't think about the ramifications. So you ask, in which class do you study? So this child is likely to answer, I study in Delhi Public School, RK Puram, in class 3B. My teacher is Mrs. Chattopadhyay. My Sanskrit teacher is Dr. Shukla, and so on and so forth. So you have asked which class do you study? The answer is as simple as class 3. But the child is so innocent, he or she is willing to give you so much more information. And that is what these people who are collecting and handling and manipulating information on the internet are doing, collecting information from children. So that is why, friends, in US the problem attained very serious consequences in the mid 90s, and that is why Congress asked the FTC, the Federal Trade Commission, to study this particular problem, and as per the recommendations of the FTC, in 1996 an act was passed called COPPA. We will study more about it in subsequent lectures, that this protection of children from online protecting the online privacy, data privacy of children under this particular act. The children under 13, whenever they are giving data, it should be with parental consent only, and parents should have access to what data has been collected from the children. Parents should have right to modify such data if they do not want certain information to be disclosed by children. Then the child has already disclosed such information. So certain safeguards have been built in. Friends, such was the impact of the report of the FTC that within 4 months of the report of the FTC, Congress passed this law. And so this was really becoming a concern in the US. So COPPA applies only to information which is collected from children under 13, and it has various safeguards like I mentioned just now. We will discuss it in more detail. Friends, these are the regulation models which are followed by various countries. Various countries have their own techniques, their own ways to maintain the online privacy of individuals. Friends, there are concerns regarding storage and processing of the data all over the world over. This is the problem, this is the concern all over the world, that how data is stored, how data is processed, with whom data is shared, These are the concerns. We have just seen some of the concerns. So, different countries have taken different approaches, different ways to solve the problem. Some countries have gone in for very strong legislation like UK. Some countries like US gone in for self-regulation model, and some other countries like some EU countries have gone in for third-party audit, reliance on third parties, third-party audit to set and enforce the standards. In India also there is largely reliance on third parties to audit. So, for example, KPMG in Ernst and Young, they are certain organizations which are conducting third party audits to enforce the standards of data protection in India. Various jurisdiction, the study has been undertaken, and the study of various jurisdictions has revealed that most countries are using a mixture or combination of all of the measures which I told you, the legislation, the self-regulation and third-party audit. Most countries are using the combination of such the measures. I am going to give you as a case study the case of US, wherein in the mid 90s, the Congress asked the FTC to study this particular problem, and in 1998, the FTC gave a report called Privacy Online, and there were 4 main principles which were mentioned in this report. The 4 main principles: the customer should have the notice of what kind of data information practices that particular website is following. So that on the website the data privacy should be there. So on any website you go now, you will find the data privacy policy of that website, that company is mentioned. Friends, the customer should have choice. Whether the data should be, how it is to be used and how it is to be disseminated. I will talk to you something about the tape disclosure, friends, in this regard. Then friends, customers have the access to whatever data that is to be collected. That is very important. So that is the mentioned in the Congress report to Congress by the Federal Trade Commission, that the one of the principles that should be there on any law that Congress chooses to make is that the consumers or the customers should have access to whatever data that is collected by them. Friends, these are also, if you see, they are also part of what is mentioned in the OECD principles. So again, it says that the consumer should have sufficient security about with regards to the data collector, the security from the data collector, because the data collector may be in a position of strength, and so whenever somebody is in a position of strength, the other person, the other party has to be provided security. That is the whole concept of fundamental rights. So because state is very strong, so individuals, citizens, in some case even non-citizens, they have to be given security, protection from the state, and those are fundamental rights which are protection or security to the individual from the state. So similarly, the consumers should have the security from the data collector. So the 4 principles: notice, choice, access and security is the basis of the report to the Congress. Friends, I mentioned something called tape disclosure. Have you ever called up a call center? Of course, you would have called a call center to find out about your credit card or your bank account, or to get your new geyser installed, or there may be a problem with your washing machine. You want to have a technician come and look at it. Your new exercise bicycle may not be functioning properly. There may be a warranty issue. For these reasons, you would have called up a call center, because nowadays that is how the complaints are taken. Service requests are taken. Friends, have you heard of this kind of a line? This call might be monitored or recorded for quality assurance purposes. Friends, this is a tape disclosure. The customer has a right to be informed that his conversation is being recorded. Every person has a right in law to be given the information that his conversation is being recorded. He also has an option in most cases to say that, look, I don't want this conversation to be recorded. So, in India, for example, in the US, for example, as part of giving a license for the call center, one of the things which the government mandates is that there must be certain systems which ensure that the call recording does not take place on certain systems, on certain computers. So, for example, I call up a call center, let us say I call up Amazon call center, and I get a tape disclosure saying that this call might be monitored or recorded for quality assurance purposes. Now, I do not want my call to be recorded. I will tell the representative who answers my call, look, Mr. X, I do not want my call to be recorded because I am concerned about my privacy. So, that executive will transfer the call to a terminal, to a computer. It is usually the team leader's computer or the supervisor's computer or any other computer where the call recording facility is not available, and therefore, there is no way that my call can be recorded. It is a violation of law, friends. It is the violation of the Information Technology Act if calls are recorded without consent. Any conversation, if you are recording on your mobile phone, it is an violation, and you have already studied the same in your Evidence Act when you studied that case of Malkani, K.R. Malkani. So, the same case holds the field even today, and the same is also applicable in the case of data privacy. It is interesting to see how various aspects of law seamlessly merge, and so that is why a good student who has a thorough understanding of various concepts of law will be easily able to interlink various concepts, friends. Friends, like we mentioned, we are going to be studying now the position in USA and what kinds of privacy protection measures are in place. As per this FTC report, within 4 months, the Congress, US Congress, which is the lawmaking body, the equivalent of Parliament, they enacted a law to protect the privacy of children, and this law is called COPPA, or Children's Online Privacy Protection Act. So, the FTC proposed that for children there must be a law, and accordingly the Congress made a law that in the case of children under 13 years of age, the notice is required about the data collection practices. The parents have a right to know what are the data collection practices of the website. There has to be prior consent of the parents when data is collected from children. Such consent of the parent must be verifiable, which means you should be able to have proof that actually the website has taken consent from parents. They should give notice to the parents before sharing information with anybody else, any other third party. Parents should be able to review, and parents should be able to even change the information which has been given by the child. So, COPPA has a safe harbor provision. Friends, what is a safe harbor? We have seen a harbor, a port. Supposing this is land, and then there is a port which will come like this. So, here this is the space where the ship can come. So, this is called a safe harbor. So, supposing I will again explain. So, this is the boundary of the country, this is the land boundary. So, the land boundary is never straight, it is going to be an indented coastline. This is land and this is water. So, if there is enough space, you can build a good harbor here. So, Bombay for example, Visakhapatnam for example, Cochin for example, these are all good natural safe harbors for ships to come in. So, similarly in law they call it a safe harbor provision. The safe harbor provision in COPPA is that the industry groups can seek the FTC approval for self-regulatory guidelines in certain cases. In certain cases, you can have the FTC guidelines also, like you have in the case of adults. Friends, in the case of adults, no law has been made in the US, unlike in the United Kingdom. the FTC says that for adults, the self-regulation with regards to data privacy by the website, by the data collector, is the best way forward, because self-regulation, they say, is least intrusive and most efficient means to ensure that the information practices for collection of data are proper. Law is not required as of now. As of now, no law is needed, but then friends, we have to understand that self-regulation will be effective only if the businesses are choosing to become part of this exercise. Like they say in India, mano to Bhagwan, na mano to patthar. So if you believe in it, if you become part of the exercise, only then self-regulation will be effective. It has to come from within. The organization has to choose to be a part of this exercise. Many businesses jumped onto this bandwagon, either because they are committed to data privacy, because they are good organizations, or because they wanted the commercial advertising, and commercial advertising will only come if you are following these data privacy guidelines, or they joined the data privacy guidelines because they did not want to lose out on consumer business, but many others have actually not joined, friends. So friends, apart from this, there is the SEAL programs, the SEAL initiatives. It's like any certification, maybe like ISO 9001 in India, something like that it is, or the AgMark, or like in India the BIS certification for gold, Bureau of Indian Standards, or the most famous ISI mark in India, which is again issued by the BIS, Bureau of Indian Standards. So just like these examples I've given you of SEAL, so similarly the SEAL programs are there in the various parts of the world, wherein the certain organizations, it may be governmental organizations, it may industry bodies, it may be third parties who are giving a seal to the website in question, and this seal serves as a certification of quality. Seal programs are offering the easy way for consumers to identify websites which are following the various good informational practice policies. So we all want to do business with entities which follow good practices, and at the same time they are providing opportunity for business to display the compliance with good information security, data security policies. Friends, in Japan, for instance, in 1998, the Japan Information Processing Data Center started granting this seal to websites that followed the approved data security policies. From late 1990s onwards, the United States also started to have online seal programs for websites. Such programs require the websites are required to obtain a license from the person who is giving the entity who is giving the seal, and the licensee is required to abide by codes of online information practice, and the licensee is also required to submit to various kinds of compliance, various kinds of monitoring. It may be some kind of third party audit. Friends, the first ever such a seal granting program that happened in the US was Trustee. So like we write in English, Trustee. So there this company decided to call themselves Trustee. It is an independent US non-profit organization, and it was the first to offer the privacy seal in the US, and they had a licensee agreement which governs how every licensee website will collect and use and store the personally identifiable information, the personal data of the data subject. Friends, it is very, very comprehensive approach followed by this particular entity, that the licensees are required to follow guidelines for notice, for choice, for access, for security, just as in the case of COPPA guidelines for children. Just as whatever COPPA mandates for children, it is mandated for everybody. So they also have provisions for third party audits. They may require on-site review, wherein a third party auditing firm, I gave you some examples, EY and Previously, even Anderson was doing this, Arthur Anderson, PwC. They are doing this auditing, and they may be called in, and this trustee also plays a part in resolving the complaints about data collection, data privacy from consumers. They provide reporting of complaints, and in certain cases may even be referring the matter to the Federal Trade Commission. Friends, now we will have a look at how data protection takes place in the United Kingdom. As compared to the United States, in the UK, there is a much more comprehensive law. This Data Protection Act of 1998 came into force from March 1, 2000. It has greatly influenced many such laws all over the world, including in several EU countries. Our own DPDP Act of India, which came in August 2023, is largely based on the architecture of the Data Protection Act of 1998. The Data Protection Act has laid down the rules for how the personal data is to be collected, how it is to be stored, manipulated, processed, and it applies to both data collected in paper form as well as in electronic form. Any entity which is carrying out the processing of personal data is required, it is mandated under the Act to follow the various principles of good practice, and these are on the lines of the OECD principles only. The fair and lawful processing of data must take place. It must be for the limited purposes only, the purpose for which it is intended. Data must be adequate, it must be relevant, and you must not be correcting the unnecessary data should not be collected. The data must be accurate. It should not be stored longer than necessary. The moment the requirement finished, the data should be destroyed. The moment the need for the work is finished, the data should be destroyed. It should be processed in accordance with the rights of the data subject. It should not be processed in a manner that affects the data subject. Friends, this data is to be kept secure at all times. You must put in place, the person who is collecting the data collector must put in place strong and secure systems at all times. And this data is not to be transferred to countries who do not have adequate protection for data security. Now, this is something very important which has influenced the position in several other OECD countries, and even under OECD principles, when they talk about accountability, the 8th principle, they are talking about the fact that data should not be exported or stored in any country which does not have a adequate system for protection of data. Friends, under English law, the model is imitated by several EU nations, and our own law is based on this particular Act of 1993, which I was just mentioning to you. Friends, an important provision of this Act is Section 15, Subclause 2, which is only concerned whether requests for information which are pursuant, the request for information pursuant to access request under Section 7 has been complied in a proper manner or not. So, whenever customer makes a request to a data collector under Section 7 of the Act, whether that request is being properly complied or not, the monitoring mechanism is there under Section 15, and if there is any breach of the data protection, it must be immediately reported by the data collector. Any breach has to be promptly reported by the data collector. So, that is again one of the important aspects of the English law, friends. So, moving forward in our own law, what are the provisions for privacy? So, friends, it appears, and this position may change. In fact, to a large extent, the position has already changed with the DPDP Act that has come in 2023 about how the personally identifiable information needs to be stored in a proper manner, what safeguards are there, whether it is to be revealed or not. So, for example, if you are going to apply for a electricity connection, and you have bought a new flat, whether you bought that flat for 2 crores or whether you bought it for 50 lakhs is irrelevant. You don't have to disclose the sale deed to the electricity company, and if you have to disclose the sale deed as proof, you can simply redact or X out the amount of the for which you have purchased the flat, because why should you disclose that information unless you want to. So this is the one of the provisions of the DPDP Act. But under the Information Technology Act, Parliament has largely missed out the aspect of data privacy, and they have talked about privacy. There is only one section. This is couched in very general terms, and it has limited scope. It focuses on breach of data by the authorities, the person who is authorized to collect data under the Act. It does not talk about the breach of data by private entities. So it is only talking about breach of data by entities like adjudicating officers, cyber appellate tribunal, certifying authorities, controller of certifying authorities, etc., not by private businesses. So we will just read that particular section 72, which says breach of confidentiality and privacy. This applies to any person who, in pursuance of any powers, please have a look at this, in pursuance of powers conferred under this Act or rules and regulations made under this Act, has secured access to any electronic record, book, register, correspondence, information, document or such other material. Such person, without the consent of data subject, discloses such information, electronic record, book, register, correspondence, document or other material to any other person, he shall be punished with imprisonment of up to 2 years and also fine up to 1 lakh. So, but please see the fine print, that it only applies to any person who, in pursuance of the powers of this Act, under the authority conferred on him under this Act, only to such persons. So it does not include the ordinary businesses, friends. So that is a major limitation, lacuna. Probably at the time when this Act was being introduced, data privacy was not so important in India, and because come to think of it, only in 1998 was data privacy law enacted in US, and that too only for children. For adults till date they don't have a law. In the UK they made their law only in 2000. So when the IT Act was enacted, probably it was not thought of such a big issue in India, and hence probably it escaped the intention of the lawmakers. But the situation has been reasonably remedied, and maybe even further remedied in the through the Information Technology Act itself or some other legislation. But for now the situation has been reasonably remedied by enactment of DPDP Act in August 2023, Digital Data Protection Act. Friends, what are the international standards for protection of data privacy? There is a discernible difference, first of all, in how different nations the world over perceive data privacy. Europeans view it very differently, for example, as compared to Americans. I told you previously that in Europe, it is absolutely inconceivable that to access basic services you will be giving out your driving license number or your date of birth. Absolutely inconceivable. But Americans, for accessing any basic service, they will give out their driving license or mother's maiden name or social security number. And friends, in many developing countries in Asia, in Africa, Middle East, there is absolutely no notion whatsoever of data privacy. People simply go to offices where they work, put a pen drive, get customer data, sell it in the market. So Europeans, friends, are a lot more concerned than peoples any part of the world, and in Europe therefore you will find much higher barriers. The companies cannot routinely just make databases of customers and share it, the customer's personal information, and sell it and share it with others, and thus wholesale invasion of privacy which happens in US, which happens in developing countries, which happens in India, does not happen in most parts of Europe. Friends, in India the situation has changed considerably. Landmark judgment is there, the Aadhaar case judgment, Justice retired K.S. Puttaswamy. 91-year-old petitioner at that time, 91 years old. Now he's, I think, 96 years old, or maybe 97, 98 years old now. So 91-year-old when the judgment came out, he questioned the issue before the Supreme Court, saying that it is violation of his fundamental rights under 21, under 19(1)(a), under 19(1)(d). Also, it has been mentioned in the judgment that Aadhaar is not required to access the basic services. Now, Aadhaar is something very important, private, and because of Aadhaar, people can commit the ID theft very easily, and Aadhaar is not going to be required to access several services like electricity connection, mobile connection, etc. The concept of masked Aadhaar or virtual Aadhaar has also come in after this judgment. It is fair to say, friends, that there are no generally accepted norms specifying the standards to determine the infringement of privacy all over the globe, all over the world. There is no such standard. Like several issues on cyber law, the main villain is absence of uniformity, and dialogue will have to be initiated amongst the various countries to develop the global standards. Till the time that such global standards are developed or more uniformity is developed on data protection standards, on the data collected on websites, the countries will have to ensure data protection as per whatever they feel is the most suitable method, whether third party audit, whether self-regulation, whether law, whether through some general law, whether through some specific law, whether through a mixture of all of these. Whatever is best suited to that country, the country will have to do. Friends, in the future space, the most important challenge is that the operators, the data collectors, have to be educated that the collectors and companies which are not following the good practices of data privacy, they will ultimately lose out on business, because the customer will shy away from conducting business with them if he or she is not sure that his data is being protected in a proper manner, because gradually customers are becoming and will become more aware about the importance of data privacy. Friends, the safeguarding of consumer data is extremely important for any business to survive and prosper in the long run. So that is why the industry has to take various initiatives, and they must encourage, continue to encourage the wide adoption of fair data protection, data privacy policies. There is a need to extend such policies, practices to MSME sector, because this sector is in the days and years ahead poised to make a huge mark in the internet e-commerce business. The large corporates should follow a policy that they will not carry out any advertising on websites which do not follow good data privacy security policies. Doing so will force all websites to come on board and follow basic hygiene in this regard. Because advertising hits the revenue of the website, friends, and it is a very important tool to make people behave in a particular manner. The initiatives are like these are critical to make self-regulation a meaningful exercise, because in large parts of the world the data protection is being conducted only through or largely through self-regulation, including in such a large internet market, largest internet market in the world, which is the United States of America. Friends, industry must increase its efforts, double its efforts to develop the effective technology and provide the consumers, the customers, with tools through which the customers can safeguard and protect their own privacy whenever they are visiting the various websites. Lastly, friends, in future it is likely that the consumers will get more educated. NGOs, government, the industry itself will carry out, consumer groups will carry out the consumer education programs, and industry and government and consumer groups will come together to educate the consumer about safe practices online when it comes to giving out data online, about protection of privacy on the internet. So friends, that completes the discussion of data protection, and I hope you have enjoyed this lecture as much as we have enjoyed bringing it to you. So look forward to seeing you in the next module, the 8th module of this course on cyber crimes. Thank you very much.